One of the most frustrating things that I've come across in the last few years has to do with pseudo lawyers and mumbo jumbo, fake law, and making up nonsense from what you could only describe as charlatans. And snake oil salesmen. What I mean by that is, about 10 years ago or so, the arse fell out of the property market. And the consequence of that was very serious for many, many people, including myself. The fundamental problem was that every person who owed money, whether it was on a commercial premises or on a family home, they borrowed the money. It was probably uncontested that they owed the money. It was probably uncontested that a demand had been made by the bank. And consequently, a legal defence in those circumstances is very difficult. In other words, you're looking at a very, very fundamental, basic contract. I go to the bank and I borrow $1 million. It's a contract between me and the bank. I have to give the money back at some stage. There's a plan to do that, but ultimately, if the crapola hits the fan and the bank look for the money back, I'm in difficulty unless I'm able to sell something to give them the money back. But from a legal perspective, from a legal defence perspective, it's very, very difficult to defend, because it's a very straightforward, very net issue. And yet, an industry sprung up from time to time over the last number of years with fake lawyers spouting pseudo-legal mumbo jumbo and quoting Breton law and all sorts of antediluvian nonsense. Muppets. Leading people astray, leading people to think that there was an easy way, that they didn't have to pay the money back, that it wasn't their fault, that it was the fault of the politicians, it was the fault of the developers, it was the fault of the Germans, it was the fault of the EU, it was somebody else's fault, but it's not your fault. But the fundamental was, people, fortunately or unfortunately, were making decisions to borrow money, and ultimately they were unable to pay it. Now, in those circumstances, as I say, a legal defence is very, very difficult. But when the charlatans and the Muppets come along with the pseudo law and legal mumbo jumbo and the legal equivalent of holding hands and singing Kumbaya and hoping it'll go away, when those people sprung up, it led an awful lot of ordinary decent people astray, and the consequence was that those people ended up with even greater legal costs, with years of frustration and misery and going to court and going to county registrars, applications, notices of motion for possession, and so on and so forth. But the crap that was spun, the snake oil that was sold, has made it very, very difficult for many people who bought it hook, line and sinker. And I've come across situations myself where I've tried to help people, and I've tried to do a deal perhaps with the bank in relation to a property in circumstances where there was absolutely no way out except to do a deal. And a deal was possible. And yet, after a while, my client would come back in and they'd be after going off to some rally or other words, or so on, in some place or other, some ballroom, where some guy with a fancy, easy, quick solution told him that, no, hang on, don't listen to your solicitor, don't make a deal, don't do a deal with the banks, it's not your fault, it's somebody else's fault, and we've an easy solution. And that didn't happen. And in my line of work, I regularly get emails. I get emails every week from the Law Society, and the Law Society sends an extract or a précis of various decisions that have been taken or made or handed down in the various courts, including in the High Court and the Court of Appeal and the Supreme Court and so on. And I have seen so many cases in the last 10 years where people have gone into the High Court and argued on the basis of some technicality or other that they didn't know the money, or that on the basis of some infirmity or imperfection in the documents that the bank might have, or that the debtor alleged that the money wasn't to be paid back. And in every single situation, I haven't seen one where a technical defence like that succeeded. In other words, in the decisions that come into me from the Law Society and to every other solicitor for that matter, where the bank is looking for summary judgment or repossession of a property against the debtor, by and large, in 5 to 99% of cases, they've been successful. Because, as I say, the fundamental is you borrow the money, you need to pay it back. And if you can't pay it back, there's no legal defence. Now, you may have a political argument, you may have a moral argument, you may have any number of arguments, but you definitely don't have a legal defence in most cases. And you saw that with the Quinn case, where the whole Quinn family trooped in to the High Court, and at the end of the day, they did what everybody has to do. They cut a deal. And as Uriah Heep's mother in David Copperfield advised them, Uri, make terms. In other words, you need to do a deal. And as I say, the Quinn case, the Quinn kids case, where they all argued that they weren't going to be bound or held accountable for the guarantees that they gave Anglo-Irish banks, all of those defences, all of those arguments went out the window, quite frankly, and they ended up doing a deal and accepted that they owed an absolute buttload of money to Anglo on foot of the guarantees. So the arguments at the outset were something to do with they were being pressurised or put under duress by either A, the bank, or B, their father, Sean Quinn. But when the rubber hit the road, when the case opened up, they wilted and they ultimately accepted and signed up to accept responsibility for the debt. And that's essentially what's been happening for the last 10 years. As I say, I've seen a lot of cases being reported by the Law Society. I haven't been involved in any because I'm going to stay out of the High Court. In cases like those, you know, there's no defence to that sort of a situation. Generally, it's very, very difficult. But the technical defences, I haven't seen any succeeding. What I have seen succeed is deals with the lenders. Different lenders take different approaches, but the bottom line is it's a far better approach, in my view, than engaging in this legal mumbo-jumbo, this pseudo-legal gibberish, and listening to snake oil salesmen and muppets and charlatans telling you that there's an easy way out of $1 million or €500,000 or €2 million debt. There isn't. There's no legal defence. If you borrow the money and you can't repay it, in most circumstances, as I say, I can't be absolutely blanket 100% across the board and make that assertion, but I can guarantee you, by and large, you've seen it yourself. You've seen the defences put forward, you've seen the technical arguments, and at the end of the day, what happens is the debtor, the person who owes the money, ends up owing even more money because of the legal costs of going to court and making these arguments that are bound to fail. Hope you find this video useful. Hope you don't find it too depressing, but it's depressed me from time to time over the last 10 years when I met decent people who were actually led astray by amateur lawyers spouting nonsense. Hope you find it useful. As I say, if you do, give it a thumbs up down below, and thank you for your support on my YouTube channel with the shares, the likes, the comments, and so on and so forth.